Good morning, everyone. Our in-person participants today and our virtual participants, thank you for being present and contributing to our workshop this morning. On December 1st, 2025, the clerk's office issued a notice of workshops regarding the commission staff's formal review of its regulations pursuant to South Carolina Code annotated section 1-23-120J. And today's workshop for docket number 2025-303E related to South Carolina Code of Regulations, sections 103-300, and all the sections that follow in that chapter related to electric systems. So we were going to host a workshop today regarding a review of those regulations. Okay, so if we can right now, let's see who's present and participating in today's workshop for the South Carolina Department of Consumer Affairs.
Hi, good morning, Jocelyn. Roger Hall with the department.
Thank you, Mr. Hall, for participating today. The Electric Cooperatives of South Carolina.
Charlie Turaney for the co-ops.
Thank you, Mr. Turaney, for participating today. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Morning, Jocelyn. Sam Wellborn here on behalf of DEC and DEP, along with my co-counsel, Tekla Henderson.
Thank you both for participating today. Carolinas Clean Energy Business Association.
Jocelyn Richard Witt and also John Burns from Seceda.
Good to see you both. Thank you for participating today. Dominion Energy South Carolina.
Good morning, Jocelyn. I'm Chad Burgess, and with me today is Elizabeth Hutton and Michael Anselmo.
Thank you. Thank you all for being here and participating today. I have a letter, and there's a letter posted in the docket, everyone dated April 7th, from Ms. Mixon and Mr. Gooding. They both represent the Southern Environmental Law Center, and they indicate in that letter that they're unable to participate in the workshop scheduled for today, April 17th. South Carolina Office of Regulatory Staff.
Ben Mushin and Claire Benge on behalf of ORS.
Thank you, Ms. Benge and Mr. Mushin, for participating today. Okay. Now, everyone, what I hope we can do this morning is we will start with the comments that were filed in the docket. I really just have one topic I want to talk to you all about. I should have brought it up actually. Mrs. Turaney, I know you participated in ORS and, Department of Consumer Affairs in the workshop on March 6th, but I didn't bring it up. But it's the phrase is in quite a few of the commission's chapters of its regulations, and that phrase is member of the household. Member of his household, But we're going to talk about it today, and in our other follow-up workshops, we'll bring this topic up again. So that's the only topic staff has for your consideration today. And when I look in the docket, let's see, on April 7th at 4:06, Dominion Energy South Carolina filed its comments related to today's workshop. And then at 4:46 on the same day, Department of Consumer Affairs filed its comments. So if it's okay, today we're going to begin with Dominion Energy South Carolina. Please.
Sure, and you want us to start with Article 3 or the member of the household?
Not yet, because
okay.
I do have some information that I want to provide first, and I foresee us having a follow-up workshop on this anyway. But so this can wait until afterwards, if that's okay with everybody.
Yeah, perfect.
Okay.
Just wanted to make sure I was meeting expectations.
Yes.
So I think everybody's seen our letter. I'm not going to go through it line by line, but
Okay.
I will just highlight the ones that we have suggested revisions to for the record. The first one's 103-315, the incident number. I mean, frankly, the purpose behind the increase in the number is it's antiquated. I mean, construction costs, everything's gone up. I mean, I just put in some improvements at the house, and I thought it was de minimis, and it was well north of $15,000. So every time something happens, it's a onerous reporting requirement. So we suggested an increase there to align with sort of modern cost. I think that number has been in the reg for quite some time. Customer deposit section, I think the explanation is self-explanatory, but the company has asked that we add a subsection 6 that allows the company to align the reg with the contract to take a deposit on a termination charge to further protect its customers from the event that the termination charge, if you wait till the end and the company's insolvent, might not be collectible. But if you get a deposit on it on the front end, it protects the customers later on from perhaps having to make up the shortfall through that from the defaulting entity. It's applicable only to non-residential customers, really the large industrials. And I didn't know if you want me to pause for each one and see if anybody had questions.
I wanted to, if I may just ask,
Sure.
if we can just go back 315 for a second.
Yep.
I understand what you're saying about the cost estimation. I was just wanted to ask if you have justification
For the 100?
not just for the 100. Is it possible for us to use, since the inception of this regulation, staff to use maybe inflation since that time period to arrive at
The number?
Figure. That's the word I want.
You know, I usually am pretty good about finding when the 15,000 got put in. I think it was at the original pass of this, so it's been quite some time. I did not do the math on the inflation rate. I think the main takeaway from the company's part is it does need some level of increase, and we're not wedded to the 100,000. The reason we went that level is the business side said that would probably capture the intent of the regulation of like the significance of the damage issue, right? But I think we'd be amenable to talk maybe at a subsequent workshop, and we can do the number 2 on the actual number itself. But the company's position, it just does need to increase on some level. Otherwise, you're just reporting every minor thing that happens. And I don't think that's the point of the regulation.
Okay.
Which I know is not the point of the regulation.
All right. And I see this is, but I think section 6 is really for, as you said, where there's a customer contract with the termination charge, because don't we already have language for, I think it's about the parent company?
Yes, you do. It's A5. Yes, ma'am.
Okay.
This is a different situation. That is when industrial customer or non-residential customer is experiencing financial risk or their credit metrics reach a level that the company determines that a deposit is needed to protect those customers. That's a separate issue, and we're not seeking any changes there. That actually, we've had some cases involving that, and it's worked fairly well.
Okay.
This is a new addition that imports a protection in the contract, which would, the person defaults, there's a termination charge that results, you have to litigate it, collect it. But in practicality, when a company's defaulting, insolvency is probably likely, and then you're fighting whether there's any recovery at all. So customers are left holding the bag. The other non-defaulting customers are left holding the bag. 6, what we do is we collect the termination charge on the front end, hold it in escrow. There's interest earned on that, obviously, for the utility, for the customer. It might not come to pass, and the reg allows this to be adjusted. So if they truck along for a little while and everything's going well,
right,
we can have discussions and return the money, right? But this is just a approach to protect other customers from instances where the termination charge is not recoverable.
Okay.
Yeah.
All right.
Jocelyn, let me
Yes, sir.
just add on here so you understand exactly what the termination charge is for. So typically when you have a large industrial customer, the company is usually required to build some assets in order to serve that customer. So it could be a switching station, it could be a new transmission line.
Okay.
And the cost of those assets that are being driven by the need of that customer are recovered from that customer through their rates.
Okay.
And what happens is sometimes you will have the termination charge is an agreed upon term in the contract with the customer.
Okay.
But what happens sometimes is the customer doesn't like Michael said, they don't fulfill their entire contract and they go out of business,
Mm-hmm.
or they decide to pick up and move to another state for whatever reason.
Mm-hmm.
We've got those assets that are still there. They're more or less stranded assets unless another customer moves in and starts
Right.
using them, and that's sometimes what happens. But we've seen instances in which the large customers are just walking away and they're not even paying the termination charge they agreed to in the contract. So that's what this is designed to do, just to protect customers and the company against having that stranded asset in the event that a large customer, doesn't pay the termination charge when they decide to either file bankruptcy or move their location or move their business for whatever reason.
Okay. Thank you very much. Okay, Mr. Hall, I'm going to go back to you if you don't mind. Do you have any comments that you'd like to? I know you have your own comments, but around 315 that Mr. Anselmo proposed, that number updating the estimate.
No comments.
Okay, and what about what we just spoke about, the termination charge? I'm
No.
anticipating you were going to say no. Okay. All right, and then let's see. Mr. Terani, do you have any comments so far about 315? Or
No, ma'am.
okay, thank you so much. Mr. Welborn?
Just that we support Dominion's positions here. Yeah, like them, I expect that $15,000 threshold is pretty well out of date at this point. And Duke Energy, Carolinas and Duke Energy Progress experience the same, or have experienced the same issue with respect to the termination charges. And so, yeah, adding it to the regulations, I think, makes good sense and should provide additional protection to other customers. Kind of to Mr. Burgess's point, if the large load customer or a manufacturing customer or commercial, if they leave and they're not paying that termination charge, then, somebody's going to have to pay for it, right? And so it makes good sense to sort of strengthen that customer protection in the reg.
Thank you. Mr. Burns and Mr. Witt?
Nothing to add here. Thank you.
Thank you. Okay, and then Ms. Bench, do you have anything at this time?
So we're just talking about 315, right?
Okay, yeah, 315, and then we'll move on. If you 315 related to the property values. No, I'm sorry, repair costs.
Yeah, we don't have a position on that. We'll defer to the commission on the
that
number.
one. Okay, and what about what we were just talking, the termination charge and larger customers who may end up walking away from investments?
No,
Okay.
no comments on that.
Thank you so much. Okay, Mr. Anselmo, thank you. We'll keep moving on with your other suggestions.
Sure. In 332, the company's looking to address, I think, something that maybe a donut hole that existed in, the real world, where you have a new or existing customer establishing service at an address that's not been occupied,
Mm-hmm.
or where the utility has not previously provided service. The current way the reg is drafted, there's no way to sort of estimate a deposit.
Yeah.
This is to close that gap in the reg. So you would estimate it the utility would estimate the expected usage given, characteristics of the facility, what is it designed to do, et cetera, et cetera. So
Okay.
closing what we think is a gap in the reg.
So I want to ask you, so if it's a new customer, is this a new home perhaps? When I say new customer, if it's a new structure, I didn't mean new customer.
Yeah.
It's new structure. We're talking about someone who's moving into a new home, like a brand new home, possibly or not.
Possibly. I mean,
Okay.
you could think maybe even a large development, they're building these,
Okay.
or this could be industrial. It could be anything. It's just a facility that is newly constructed,
Okay.
or a facility where the utility hasn't previously provided service. Basically, it's a just brand new situation for the utility one way or the other.
Okay. And I was just curious about the estimate that you, would you look at other structures with similar square footage, similar developments? I'm just curious about your methodology. Had you?
Yeah, I mean, in consultation with the business folks, they have a pretty robust way of doing these things, and
Okay.
it is that. I mean, for instance, if it's a new facility that's going to be manufacturing steel, that's probably going to be a pretty giant number.
Okay.
If it's a 2,100 square foot single family residence, we have the data that
Okay.
can be used to estimate that usage. So,
Okay.
yeah. It would not be. It would be supported through the company's records and experience and things of that nature.
Okay. And not trying to take Mr. Elliott's job. I know he represents the energy users, but I'm wanting to ask one other question. So if it is a new development like that, in your negotiations with the customer, you all provide that information. Like these are the, gotcha.
Yes, ma'am.
All right. Thank you for that. So now we'll go back to you. Any comments, Mr. Hall, at this time?
No,
That's all right. Okay, I won't come back to you until you raise your hand then. I can't see our virtual participants. Mr. Terani,
I'm good.
you're good? What about you, Mr. Wellborn, right now?
We support the update there.
Okay. Mr. Burns,
Nothing to add, ma'am. Thank you.
thank you. Boris,
So, I'm sorry, we're just on 331.
that's
right?
it, yes.
Yep, no comments on that.
All right. Okay, 332, amount of deposit.
Oh, we are on 332 now?
Yes, sir.
Okay, so on 332, I'm not really opposed to the problem they're trying to solve. I think the question we had was, how do you estimate expected usage at a new location? I think it's the same comment that you made. Do you do that on square footage or how do you do it? So I think it's not so much the concept as it's more the methodology of how do you go about doing that.
Yeah. So as I read Mr. Anselmo's comments too, I was wondering, I said, there's another area in the regs, another section where the utility provides that their methodology to ORS. The commission receive it because it's not part of a case. You know what I'm talking about?
I do.
So anyway, I was thinking the same thing here, maybe for residential customers, but I felt like if there was a recommendation that the commission wouldn't need to receive that information, that you all may just want it for your records. Does that make sense?
Yes, I'm still puzzling. I know exactly what you're talking about.
It's the credit risk matrix where when we tell a entity that, hey, by the way, you are now at a credit risk, we have a matrix that we have provided. It's been a minute, but y'all have had it for quite some time. I mean,
that very well may be.
I would assume we could put something similar together for this. Yeah.
Yeah, I think it's just a question of, if we get a call from a new customer and they're complaining about it, then what's the methodology behind it? Whether it's presented to us or whatever it may be.
Yeah.
I think
that's fair. We're happy to work together to formalize this. I think probably should have done it in the comment letter. We didn't actually think about it, so this is a good point. But no, not trying to hide the ball here. We're happy to work with something there.
No, I get it.
Yeah. Yeah, thank you, Mr. Anselmo. That was the only thing that came. The larger customers are more often than not represented, right? I know you may receive those comments, but they're probably represented by counsel. Thank you, Mr. Anselmo, for that. All right, let me see. So everybody, what I'm going to do moving forward, as Mr. Anselmo finishes each section, I'm just going to ask ORS right now, unless someone says, I want to talk. Okay? Is that okay? All right. Mr. Anselmo, 333.
Sure. We're suggesting a reduction again. It's been in place for quite some time, the 3.5%. That you don't get that anywhere these days, unless you're paying a mortgage. But the fact of the matter is, when the company has to hold a deposit and be able to provide the interest, the cost associated with that is then passed through the cost of service to every customer.
Right.
And frankly, it is probably likely that any individual benefit from one customer kind of washes out when the whole amount gets passed through the cost of service. We haven't run the exact numbers on that, but it probably, let's be honest, the deposit amount's not big, the interest delta's not big. So to benefit every customer, we thought a suggestion to move it down would be beneficial. I've had some preliminary discussions with DCA on this issue, and Roger might have some comments here, but it's a pretty straightforward thing. It might just be time to move it back down.
Okay, and that's commission order too, so that's something that we can place on the commission's agenda.
It's been around since 2003.
Okay,
this number.
Yeah.
Well, my first comment is I'm not investing with Michael if he can't get 3.5% anymore. But I think 10-year treasury rates over that, high yield savings accounts have been above that. But besides the number, what I was really it was a question, and as Michael alluded to, we talked about it. It's a surprise to me that this goes with the cost of service. I didn't realize that all customers are just paying this interest, and I can't say whether we're for or against it right now. I'm generally just curious if they're not investing this money somewhere. It's not sitting in escrow or something. Somehow, it's, from what I've heard, it sounds like every other customer is just paying the interest, which just seemed unusual to me. So that's really my only comment. Happy to talk about that.
Yeah. So spoke to my client. We can't put the money at risk, right? So it limits the options of what we can do. If we invested it and lost it, and that'd be more problematic than just about any other approach to this. So what I do know, what we've confirmed is that the total amount of that interest does flow through cost of service to all customers.
Okay. Yeah, that's, like I said, maybe something we'd want to ponder a little bit further, but it looked like from looking at the right, this number is not in the regulation, so this is just a commission,
No, sir, it's not. It's commission order.
So I suppose another party at some point in time, when if interest rates are getting much higher, can come back and ask for it to be increased. Yeah. Like I said, to me, 3.5% didn't seem that high. I understand things have kind of been trending down, but for the last couple of years, they were well above 3.5% as well. So
okay.
Really no position on it right now. Just had some questions.
Okay. All right. So what I'll do, everybody, for our follow-up workshop right now, I have 315. We're just going to talk about how to arrive at what the methodology to change the number, the $15,000 repair cost, right? That's the first topic. The second topic is 332, just to see what ORS and Dominion and others, whether you want us to state in the reg that the utility will provide its estimate methodology to the Office of Regulatory Staff, that we just include that in the regulation or not, okay? The third thing, and this is where I'll need your input, should we bring 333 up again, or should I just ask the chair to place it on the agenda? I can notify everybody in the docket which agenda, and if you have comments regarding a recommended interest rate, you can, state that in writing before the commission rules. Does that make sense? Because this one seems to impact, have a more immediate impact on customers, so maybe we don't want to wait till the second workshop for 333, because that's a commission order. It's not a regulation. Is everybody okay with me just seeing how quickly we can place that on the agenda, and then I can notify you of the date, and then you can provide comments?
Yeah, certainly.
Okay. Mr. Mushton and Ms. Benj, is that okay? All right, so this one is commission agenda 333.
I will tell you what doesn't make sense on this, just in case future discussion. You know how the Supreme Court issues its annual thing. That works for the court because the cost is not socialized around a utility's customers, right? That's just. But if there was a consideration of doing an annual adjustment based on how the court does it, that impacts every customer of each utility rather than just the parties to the litigation at the Supreme Court. So I would definitely suggest not pursuing that route.
Not an annual adjustment cases. Yeah. Right. Okay.
Yeah, Justin, the only thing I would add, and kind of like Roger, I would say, I think the annual T-bill CD rates, it's hovering around 3.5. So I think it's more, to recognize that while I understand minimizing the cost, it's also, this is customers' money that the company's holding. And so I think finding that balance, and then what is that right number? It may be, I don't know that it's 2% now. It may be 2% now. It may be 6% later. So what is that right number? So I think it probably warrants a little more discussion than that.
All right. All right. So do we want to, I can commit to, this is April. We can, I'll move things out of order because of this issue. We can talk again sometime late May. I'll have to look at the calendar, make sure we're not in major hearings, everybody. Or first part of June. When you said additional discussion, you mean at the workshop?
Well, I guess I just mean, like, how do we arrive at the 2%? I
Okay.
mean, is there a methodology? I mean,
Yeah.
going back to methodology, like, is there a way we're arriving that, or is it just
Okay.
we're just minimizing costs? So,
I understand.
I mean, I think there's just a balance between, I understand what the utilities their argument is, and the reason for the recommendation. But by that same token, I mean, it is customers' money that's being held. So
Yeah.
finding that appropriate balance and what that is.
Does that make sense, Mr. Anselmo? What? I think
Yeah,
we,
sure.
we
Happy
we-
to do whatever y'all want to
Okay.
do on this one.
Okay. It won't take me long to also involve Norman on this issue internally at the commission, y'all, for recommendations to you all. So I know we have an advisory meeting on May 1st.
I mean, and Jocelyn,
Yes, sir.
There's no urgency from the company's point of view on this. So
Right.
if this runs its course with the other regulations, that's perfectly fine.
Okay.
I don't want to burden anybody with pulling this one out or whatnot, but we're happy to defer to
All right.
whatever you prefer.
I think so we don't rush through it. I think we'll just, at our second workshop, we'll come back to this, so everybody will have time. Like, I want to talk to Norman about it. I know you all may have your colleagues that you want to speak to about your recommendations and potential review periods. Okay, so we'll just do the second workshop. And Mr. Burns and Mr. Terraney and Mr. Witt, I'm not leaving you out, but speak out, please, if you have something or need to comment. All right, thank you, Mr. Anselmo, for 333. What about 335?
Sure. Proposing a modification here that I think eliminates a vestige of physical offices or when we sent people out into the field where you give people an actual paper receipt. What the practice is, your receipt is now two things, actually. When you have to pay your deposit, it's on a bill saying your usage for that month, the deposit amount. You send your money in, however you pay the utility. The next month, the deposit's not on there. So you've paid it. And also, the customer service records held by the company will indicate that you were required to pay a deposit. We received the deposit, the date, the time it was received, things of that nature. So the utility is the repository for what used to be the receipt, now through the billing process and the customer service records. And the reason that doesn't really change the intent of the reg is the second part of the existing reg was the backstop anyway, which the utility had a backstop providing the receipt, right? If they lose it, that doesn't mean they lose their deposit. Mm-hmm. We had that obligation anyway. So the wording can maybe slide. I was struggling myself with how to phrase it, like maintain a record, but I think that makes sense in light of the fact that the record is the bill and then the corresponding customer service note, right? And the customer has their, I don't know if people keep bills, we do for some reason at our house, but doesn't change anything other than eliminate the physical receipt contemplated.
So may I ask you this? I understand the company no longer operates physical payment offices. Do you have, I don't know what you call them. For example, some cell phone carriers will have other locations that they contract with where people can pay their bills. Does Dominion have the same types?
We do.
Okay.
You can. Well, let me say it this way. I haven't asked in a while, but I know previously when the business offices were closing, you could go into like a Walmart and make a payment, and there was another type of payment center as well. So that option does exist.
Okay, and Mr. Burgess, so in those instances, if, as Mr. Anselmo mentioned, they're paying the bill, but a required deposit is included, the customer's receipt, because I'm assuming that Walmart, for example, will provide the customer with the receipt.
I don't know the answer to that question as far as like what paperwork goes back and forth between the customer, but to Mr. Anselmo's point, when they do get their billing statement will have a record of that deposit being paid by the customer.
Okay. So it will show what was paid for the previous month, basically.
Yes. Yeah. Frankly, the onus shouldn't be on the customer to keep a paper receipt anyway, right? I mean, that's basically the brass tacks of it. That's an antiquated way of doing business, frankly.
I'm antiquated. I'm not saying that to be sarcastic, but I know there are other people like me who just, just do stuff like that. So that's the only reason why I asked. Not that
My wife still balances her checkbook and with her app on her bank next to it with the actual justification next to it. So I might, I get it.
You okay with this, Mr. Hall?
No comment.
Okay. What about you, Mr. Buster?
No comments.
Okay. All right. Okay. Payment. Okay. Thank you so much for that explanation. Let's see. Where are we now? We are on 352?
352A1. We have
Okay.
two parts on this one. The A1 is, I wrote a lot of words for something that's really straightforward, which is the personal interview thing.
Yes.
I mean that's just irrelevant at this point for the reasons I mentioned earlier, plus with the technology products that the utility uses to do this. It's in the reg, and we don't like superfluous language and regulations, so we suggested dropping that.
Okay. Okay, I'm moving on then to 352A3B.
Man, we're rolling. So A3B, the medical form, the addition is to make the form come directly from the licensed physician. And here's why. Recently, the company audited this process and the paperwork.
Okay.
And the first 10 certificates that were received from customers that got audited, 7 were forged.
Okay.
So and we receive a large number directly from physicians anyway, and that is just an easier way to ensure the accuracy of this because it matters, right? Okay. So that is the only change. Nothing on the form changes, nothing on what's the physician's looking at, et cetera. Nothing changes substantively. It's the physical delivery needs to come from the doctor.
Okay. All right. And it can be emailed to the company under your proposal or faxed or whatever. They don't have to use U.S. mail.
Yeah, the form gives you 3 options.
Okay.
You can do it by mail, email, or fax, and all those numbers, addresses, and email addresses are on the form at the bottom.
Okay. Mr. Buster, any thoughts?
The only thing which I certainly understand that is a lot of fraudulent certificates was if we're going to put it in a regulation, maybe say licensed physician or their staff, just so that there's obviously if my dad was a doctor and I don't think he would have loved that. He would have shipped that off to his nurse, but anyway.
Yep, that's a good ad.
Okay, I'm going to say right now, licensed physician or physician staff. Okay. Okay. Is that it for right now? Okay.
That's it.
Thank you, Mr. Anselmo. Let's move on now to Mr. Hall, please.
Thank you, Jocelyn. Like Mr. Anselmo, I'm not, won't rehash everything from our comment letter. We had 2 suggested revisions to 103.339, both meant to increase transparency for customers. Basically, just feel like it's too difficult right now for customers to find all the information to understand what goes into their final bill payment. I think that's true whether you've received a paper bill or an online electronic bill. Kind of three main reasons for this. As we noted in our letter, we're the Consumer Protection Agency in South Carolina. Have a bedrock principle of federal and state consumer protection laws is transparency. We understand that utilities are different. It's a monopoly. This isn't shopping around, but still the same principles apply, we think. Second reason, and I'm gonna not trying to pick on Duke a little bit, but these issues kind of first arose for us in some Duke dockets. Duke, well, the way I understand it is Dominion doesn't really show any riders. Duke was doing a summary of rider adjustments. So it's all the credits, all the charges kind of lumped into one. So what we were seeing in that particular docket was customers were seeing a negative, they were getting a credit.
Okay.
But that credit was really a $6 charge and a $7 credit, basically somewhere around those numbers.
Okay.
So we just thought that could be a little bit clear that, hey, you're actually paying for something here. And through those dockets and others, we kind of worked with Duke on that, and they have agreed to make some changes, which we appreciate. And then the third, again, not to pick on Duke, was on an EEDSM docket. And so in that docket, can clear Duke spends a good amount of money marketing their EEDSM programs, understandably, and the commission has increased that over the years. So we thought that a simple, low-cost way to get notice to customers that these programs exist is to let them know they're paying for it.
Okay.
And so by putting that line item on the bill, they'll see it, and more likely, we think, to participate if they know, I'm already paying for this program, so why wouldn't I participate in it?
Mm-hmm.
So those are kind of the reasons. I talked to Dominion Council, saw Duke's letters, and talked to Tech a little bit this morning too. Certainly understand that they might want to review these issues a little bit further, see what kind of impacts it has on them. I know there's maybe a comment about some sophisticated customers. I think we'd be happy with it for residential customers only.
Okay.
I think if you see what we suggested too, was that the credits maybe could be grouped together. But really, what I think we'd want to see is that EEDSM being an item that stands out. But certainly, again, willing to talk to the companies if we're not realizing how complicated it might be for them, how many riders there really are. Does that create confusion, that kind of thing? But so really just looking to increase transparency for customers on the bills.
Okay, perfect. And I'm definitely just going to include this in the second workshop. I know everybody else, we're going to get some more comments, but just based on what you said, I think you're going to continue to talk to the companies, Mr. Hall, if that's okay.
Yeah, happy to.
Okay, all right. Is that it for right now?
Yes.
All right, thank you. We're going to move now to, I'm just going to ask if you all don't mind at this point, Dominion Energy and Duke Energy, Carolina's in progress, and then I'll come to ORS unless someone else says that they have comments. All right, Ms. Henderson?
We do have comments
Okay.
on Mr. Hall's
Yes.
proposal. So would you like to take our comments on that first, or I wasn't clear. Did you want to?
Jumping ahead.
Okay.
No,
Yeah, no, I don't
think
want to
Mr.
jump ahead.
Mr. Nzema, do you mind if he moves forward? Okay, go ahead, Mr. Welborn.
So first, I guess we appreciate and understand the desire for greater transparency.
Mm-hmm.
But if you think about the riders and schedules that we operate under that are approved and filed with this commission, the general service just tariff, as one example, is 3 pages long. The residential service tariff is 2 pages long. If by the plain language, as revised by Mr. Hall, it would require us to attach those tariffs to the bills. We have how many hundreds of thousands of customers do we have in South Carolina? 800,000, I want to say, customers in South Carolina. A vast majority of them still receive paper bills in spite of having electronic bills being available to them. And so I just sort of shudder to think what the increase in cost would be were we to be required to include not only, for example, their base tariff, the residential tariff, but also the EEDSM tariff, also the, EDIT tariff. I mean, there are a number of tariffs that we bill customers under. And if each individual bill of 800,000 customers is increased from, a page and a half, 2 pages to 10 or 15 pages, it's I don't know that that's what Mr. Hall intended necessarily.
Okay.
And so we filed a letter yesterday, and
Yes.
apologies for that. We wanted to be clear and for folks to have our thoughts, I guess, before we enter today, so as not to surprise anybody. But one potential alternative way to modify that regulation is on this second page of what we filed, which is the applicable rate or identification of the applicable rate schedule, and then keeping the language that we would provide that rate schedule to customers should it be requested. And so certainly we want to identify the rate schedule by which we're charging customers. We don't want that to be confusing or misunderstood or opaque, but attaching, each individual rate schedule to each individual customer bill every month over, the expanse of our customers is, would be extremely burdensome and costly.
Okay.
So those are the thoughts there.
Mr. Welborn too. So that's dealing with D.
That's
Okay.
right.
And you're about to talk about L.
Yes, ma'am.
Okay.
And so on the other one, as noted in our letter, we've entered into a stipulation with the consumer advocate to break out the SORA charges, which are inclusive of the EEDSM rider. And so I believe Mr. Hall's concern there is already resolved with our agreement with the consumer advocate to display those differently in our bills. I know that DEC has done it one way historically, and DEP has done it another way. DEP being the approach that it seems that the consumer advocate prefers. And so we've committed to going to the DEP method, to showing to breaking out the EEDSM and other rider adjustments that are included in that cumulative SORA line item on bills. So I think that resolves the concern on that. I think the other issue that we have related to this is what would go beyond what we agreed to in that stipulation. Again, primarily related to cost. And so there are a variety. I mean, I'm pulling up eTariff now. We have, dozens of various riders and services that the companies offer to their customers. And I think we would need a better grasp internally as to what the impact would be of, individually listing out each rider. And so we are a bit hesitant to whole cloth adopt that recommendation without knowing more about what it would involve on our side. But I say that to say we're already we've already committed to do what it sounds like Mr. Hall wants us to do, and therefore I don't think that L addition is necessary.
Okay. All right.
So I say all that to say we can look into it more, but it sounds like his itch has been scratched with what we've agreed to on the SORA matter. And so I guess I say that to say if we could avoid, I guess, having to go inside the company and dig into all these riders and all that, I think that would be preferred. But defer to Mr. Hall on whether that SORA agreement gets us where he thinks we need to go.
And you don't have to come. We'll do it the second workshop if you're not ready to comment, of course, Mr. Hall.
Well, I just had two quick comments. Our intent was not to have the tariffs included. What I meant with the rate and rate schedule language there was simply, for example, residential, they're under the res rate or whatever it is for each company. And that's what I assumed schedule meant, not necessarily the entire tariff. And then the rate being just the kilowatt hour charge. So if that needs to be clear, certainly understand that. And as far as L goes, I mean, yes, with Duke, once the business combination is complete, and that's what they've agreed to do. But we also, we do have Dominion here who has riders as well. So, and I don't really off the top of my head, not I guess no one else. There's no one else I would apply to, but
all right,
it would. Dominion has not agreed to do the same thing. So.
Okay.
I didn't agree to something I didn't catch. What was that? I really didn't hear it.
No, Sam was just saying that as to Duke, L is really unnecessary because we have
The SORA.
an agreement to
Gotcha.
separate those charges.
Yes.
Gotcha.
You ready to say something?
Generally,
Okay.
Roger and I spoke yesterday, so I just want to fill the group in on sort of some of the things we talked about, and we'll comment specifically on the D and L later. But a couple things that I think impact this. We operate differently from the Duke companies, right? They have a larger number of riders than we do. We have 5, I believe. But that we have 823,000 electric customers. If you add gas, you're at 1.1 million. And this impacts a couple of things. The rate schedule that the customer takes service on itemizes each of the riders and explains it in one sentence, but the schedule itself can be lengthy. So even importing the 5 sections, I mean, if you put your finger on the screen, it's this long, right? It's a couple inches. It's going to add length to printing bills. It's going to add cost for printing bills for up to 1.1 million accounts, right?
Okay.
Then we've actually workshopped this as a Dominion enterprise. And when customers were presented with their bills with more information on riders, they asked us to not do it. It was too confusing to them to understand, has it already been included? Is this separate? Am I paying this? I mean, it was a confusing situation to the customer workshop groups. So ultimately, might not be the best idea, and I don't know if it actually enhances clarity for the customers. Actually, it doesn't appear to enhance clarity for the customers. And let me give an interesting, a real world example of this. What rate schedule a customer takes service on impacts what we have to explain. And we have certain rate schedules, like our rate 5 time of use rate, that any customer can be on, right? But a subset of that category are net energy metering customers, rooftop solar customers who take under the solar choice rider. Certain things apply to them that don't apply to others. So we're going to have to tailor bills by the household for certain rate schedules. And I don't even know if we can keep up with that, frankly. We'd have to check with our teams. So just some high level topics on this. I think we do understand the intent, but we think probably ultimately our current practice of the rate schedules is clear. Our customers are not clamoring for this in any way, shape, or form. And in fact, when we bring it to them, they don't want it. So I think we can probably have further discussions with the DCA on this, but just wanted to highlight the things that we'd already sort of mentioned in other conversations for the group.
Was your office just getting, I wouldn't say complaints, concerns, or questions about a particular rider or anything?
No, I think, well, for Dominion, nobody knows they exist. I mean, I don't think they're going to look at their bill. I pulled my bill up and you see your per kilowatt hour charge and a couple other renewable energy resources and the franchise fee. I mean, I don't think people understand these exist.
Okay.
And since I did pull up my Dominion bill, that's what I have. There's also no way, I know that it exists and I know that it should be out there somewhere. If not, there's no link through my bill. I'd have to go out of my bill to the Dominion website, search things. We played this out in some prior comments with Duke as well. It should just be easier to find, we think. Again, with the millions of dollars that were spent on EEDSM marketing, we just again thought that would be a good way to find out, hey, this exists. I don't need, a commercial, an event, whatever they're spending the money on. If I see it, what am I paying for? I'm paying $6 a month for what? Okay, let me go find out how I can take advantage of that.
So not to put words in your mouth, are you more for the riders, are you really concerned about the EEDSM charge? And I use concern, is that where you would like a line item?
That's the primary one, but we do think, there should be some reference to, other credits or charges as well.
Oh, okay.
So,
yes, sir.
This is the clarity that our riders provide, the rate schedule provides from DSM. It puts out the energy charges. You've all seen the rate schedule for rate 8. It has the energy charges. And then we have a giant heading that says demand side management component. And then one sentence says the energy charge above includes a DSM component of 0.00313 per kilowatt hour for demand side management expenses. Right? It doesn't get more clear than that. And again, we've not had people calling confusion about it, and the workshops that have been done with actual real world customers say they don't want it. And frankly, I think you don't hear from it at the customer complaint hearings, clarity of the bills. People just want to know what the amount they got to write the check for is, right?
Okay.
They don't need to know how the sausage is made. They want to know, what the end product is and get it out. It just seems there are more negatives ultimately on including this just from a cost perspective and a clarity perspective when it's already being covered.
And your source there you're referencing is the tariff?
Yeah.
Is that what you're looking at?
Yep.
Okay.
Yeah, but people don't know how to go find a tariff. Nobody's going to look for the tariff. I'm looking at my bill. There's nothing about what you're talking about on my bill.
Again, the fact of the matter is no one's asking us to explain this in further detail.
It exists. Customers know
It shows
Yeah,
the trust
Roger.
they have in you, Roger. They're
Roger.
consumer representative.
I will say, don't underestimate the Dominion Energy South Carolina customer. There are people who, to Michael's point, they don't care about the details, but there are customers who do care about the details, and they call us, and we have a whole customer service department who are trained to explain all this to them. So, I would just be careful with that type of stuff.
And I understand. I just thought of one example. I think that's again from our prior comment letters and other dockets. Is eat it. and eat it falls off sometime. You know, we set this up where it'll get applied for a few years and it falls off. Customers' bills go up. I mean, you all get those calls. I mean, my bill went up. I use the same amount, and they don't know. Oh, that was this credit that you were getting for a few years. It's no longer there, so now you're paying for it.
Okay.
I mean, to me, that's a pretty clear example that I would assume they're getting calls on. That maybe, had they been used to seeing that charge, would understand. Okay, why is my bill $7 higher this month?
Yeah, we had a specific bill message on Eat It, though, that was approved by the commission that you reviewed and provided feedback on. So I feel like Eat It maybe isn't the best example because we affirmatively provided customer communications about the Eat It rider. And I struggle to think of other examples that would apply here. I mean, like I said, we agreed to break out EDSM rider charges, which I thought was the main focus. So we've checked that box. It sounds like based on Mr. Anselmo's bill, DSM is listed separately on the bill, 0.00 on the rate schedule. I see.
Right. It's not.
Okay.
Well, can we all do this though? Can we just have our second conversation? I don't know. Maybe you all will have time to talk again, if you so choose. But we'll talk about it our second one to see.
Sure.
I think this is very healthy conversation though. Everybody has, based on your experiences, you have, you know, different reasons, respectfully. So I'll include this topic too at our second workshop. And if you have nothing else, that's fine. But I appreciate the input this morning. Okay, everyone. Mr. Mushin, do you have something right now? No? Okay. So everybody, I just want to, my last topic, what time is it? 9:50. Okay. Last topic. I wanted to ask you all to think about for our second workshop. Do we need to define member of his household, which is in several of our regulations, commission's regulations. It's in the statute too. 58.5, 1110, and 58.27, 2510. And I did a search on, I really couldn't find a definition in the code. You all may be able to find one. But another phrase, which this one is very narrow, that I found in the criminal criminal offenses title, Title 16. Crimes and offenses is the correct words to use. And household member is defined as a spouse, a former spouse, persons who have a child in common, or a male or female who are cohabitating or formerly have cohabitated. And Miss Purvis, I'll make this bigger. So this is that's one, because I could not find, I was unable to find member of his household to find in our code. And then here's another definition. This is in Title 20, domestic relations, and it differs a little bit from the definition that's in Title 16, a male or female. No, actually, it's the same one. Spouse, former spouse, child. Yeah, it's the same one. Same definition.
Ms. Board, could you repeat those sites?
Yes, sir.
I lost
Yes, sir. So the
58.
the ones in our code in the Title 58.
All of them. You had 58, 5, 11, 10. Then you mentioned
Yes,
the
sir.
second one that I-
58, 5, 11, 10, and then 58, 27, 25, 10. And then
And how about the Title 16?
Title 16, okay. There's a definition for household member, but not member of his household. And that section is 16-25-10, Section 3, subsection 3.
Okay.
And then the other reference that I printed, I'm not saying these are all, but it's just, it repeats. It contains the same language, Mr. Terraini. It's 20-4-20A, no, excuse me, B, little b.
Okay, wonderful. Thank you.
Okay. Oh, no problem. So our regulations And if you do a FES search, if you conduct a FES, FESS search on our website, everyone, under docket search, you will find, I think this definition has been in member, I think the phrase member of his household has existed in the commission's regulations for decades based on prior commission orders where the commission promulgated its regulations. And I wanted to ask you all to consider us talking at our next, at our follow-up workshop about whether we think the commission should define member of his household. That's what I want to say. Getting my thoughts together. Okay. I'll start with Mr. Anselmo, and we'll just go around this way if you have any thoughts, and then I'll go to our virtual participants.
So I think Dominion and this group of lawyers have probably dealt with member of his household more than almost anybody at the commission. We've had a couple customer complaints where it's mattered, where it's been discussed, and I think we even had an oral argument about it at one point. The applicability of the Kate rule, for instance, where it's in there.
Yes, sir.
And the position has been, and I think correctly so, that the reason that member of a household is defined differently throughout the code and left undefined in other places is that it depends on the context-specific situation, the factual issues attendant to what constitutes that household. It differs, for instance, and we made this argument in the Clyde Kennedy customer complaint hearing, for tax purposes, whether you can be a member of the household, somebody claims you're dependent. It differs for criminal law. It differs. Family law differs. It's just frankly different because it has to differ because one size fits all doesn't work.
Okay.
And this is one of those, I think we've had others where a definition probably isn't practical. One, because you can't, because it depends on a factual situation. And if you attempt to define it, you may unintentionally exclude things and you may unintentionally include things that perhaps shouldn't be, which then leads to further litigation and confusion.
Okay.
This rule has been, this lack of definition has not, the issues in those cases did not hinge, or the lack of definition is needed in those cases because one set of a household can differ. The Clyde Kennedy one differed from a more recent one where we had, I can't remember the name of the other one. Yeah, we had two.
Okay.
And both situations qualified as a household, but they were different situations, different groups of people, different relationships inside of that. But ultimately, the conclusion is reached that, yes, it was in fact a household because of the nature of what was going on in the house. And this K rule, for instance, come back to that one because it is in that one, is an important tool in the utilities belt to be able to recover unpaid charges when people manipulate the system and move service from name to name, from family member to family member, to people living there and taking service and benefiting from the service. And if you define this in a way, you may unintentionally, even through best intention, limit that tool in the utilities tool belt. And when that happens, the other customers of the utility then have to pick up that slack. Okay. I understand that it occurs throughout it, but it has worked well undefined and I think appropriately. I think this is one that may be best left for the General Assembly. If they think a definition is warranty, let them provide it.
Okay.
But they have not, and it's been in there, as you said, for a really long time.
Well, I did a search, a FES search. Ms. Purvis, may I show, would you display the desktop for me? I'm going to promote DMS this morning a little bit. But the FES search is actually a result of input from our advisory committee. So we really appreciate the advisory committee asking us to invest a little more into the search capabilities of our docket management system. So I arrived at this page. It's on dms.psc.sc.gov. And then I just searched here, FES full text search. And in quotes, type member of his household. And this list, the way it's organized, I just clicked on each, of course, attachment. I found an order back from 1980. This one is from 1993. It relates to rules and regulations of the commission from 1993. And if you search for member of his household, there it is.
Yeah, I believe we even spoke about that 93 order with Commissioner Belzer in a few instances,
Okay.
the genesis of this definition.
Okay.
And as you showed some of those, I mean, obviously in the family context of domestic abuse, the legislature has deemed a definition necessary to what fits inside of domestic abuse, right? That is a unique and horrible factual circumstance, right? They provided that definition. Criminal code is different as well because it needs to be different because of specific crimes and the need for that clarity. But
well, I will tell you what, just based on, I saw several commission orders that, as I said, it's in the telephone regulations, it's in sewer, I think it's in water, the same language, everyone. And so I think what I was wondering, Mr. Anselmo, is there, you said that defining member of his household should be determined on basically a docket by docket issue, docket by docket basis. Would there be any commonalities though with this phrase as it relates to utility regulation? Is it the owner of the property that needs to be aware you could potentially incur certain liabilities because you are the owner of this property, and just by being the owner of the property, you may incur additional expenses because you're responsible for the household. That's where I'm trying to go with this. Is there anything that maybe we're not able to define everything, but are we able to define anything? So then make clear that this is not all encompassing.
So I'll answer the commonality first, then
Okay.
I'd like to get your point about the owner of the property because there can be distinctions. Okay. The commonality is people are in the household benefiting and using the service and then consistently moving it to other people's names. So it's in my name. I rack up $300. I change it over to Elizabeth's name the next month. We're living in the same house. She's benefiting from the service when I had it. I'm benefiting from the service when Elizabeth had the bill in her name. But the common is we provide the service and the folks in the household benefit from it, right? And then there are protections elsewhere in the code for landlord-tenant situations, right? So ownership is not the determining factor in any way, shape, or form. And the utility cannot make the landlord pay for the tenant, right? But let's say the tenant keep bringing folks into the house or the apartment and doing the service manipulation and avoid disconnection, right? Again, you get back to the commonality, which is the benefit of the service received by the person in the house provided by the utility at the same location, right? And
in your situation, both those persons both potentially remain in the home?
Yeah, but
I mean, in the house, because I don't want to call it a home. I think a home is so subjective.
So I'll use the example that has been litigated and is complete at the commission. So nothing ex parte here. The Kennedy matter is closed and done.
Okay.
Mr. Kennedy did not live at the property, right? He lived elsewhere, but he had members of his household related by blood and by law in that house manipulating service and continuing to avoid disconnection and a pretty substantial amount of money. And ultimately, the commission found that the K rule, the buck did stop with him, not because he owned the property, he didn't even have to be at the property, but because it was members of his household. So it's...
What about household, though?
I mean, that's just the physical location. Yeah.
Okay.
I mean,
you see where I'm going with this? That word household.
Yeah. For instance, my family lives in Louisiana, right?
Okay.
When I was, up to 25, my father claimed me as a dependent, a member of his household for tax purposes, right? I lived in Spartanburg, South Carolina, going to college. My dad had been manipulating service in Louisiana, and Louisiana Power and Light were trying to prove a household. They can't come get after me. I'm not a member of that household because I didn't benefit or use the service. Right?
Okay.
But look, another commonality is you're at the residence that's receiving service.
Okay.
Together, manipulating service and benefiting at that place, right?
Okay. I hope you understand. I'm just trying to for us to talk about,
But I think our back and forth is illustrating the point of the difficulty and probably impossibility of creating a definition of this issue, right? It is simply too fluid of a situation to lend itself to a definition. I would love to have a definition on a lot of stuff. I mean, we've supported definitions and things before, but this is one, and we made this point in multiple hearings to the commission, that it defies the ability to do so, and it needs to stay the way it is because factually each customer account and each situation is different.
Okay. Thank you for that exchange. Mr. Wellborn, do you have any thoughts right now?
Nothing too exciting. I did find in Title 58 two references to member of his household. One is at 58.5. 1110, and then there's another in the electric.
Did you find those?
5827 2510.
Yes. Yeah.
And so there it seems to. These are related to special needs customers, and it says that if it would be dangerous to the health of the customer or a member of his household at the premises to which electric service is rendered. So it sort of suggests that, at least in this context, kind of to Mr. Anselmo's point, the context, will matter, I guess, case to case. But at least for these sections, it basically says you can't, cut off power if, I won't get into the termination procedures, but it defines special needs account customer as either it would be dangerous to the health of the customer or a member of the household, which sort of suggests that it's somebody who lives there, in this context. But kind of to Mr. Anselmo's point, that may make sense here. It may, it may make different sense in a different context as well. So we can think more about it, and be better prepared to talk more through it at the next workshop. Yeah, but I thought that one code section would be worth pointing out.
Yeah, thank you. Mr. Hall? Nothing? Okay. That's it. So that's our. Oh, go ahead. Yes, Mr. Tarani.
As you pointed out, this affects more than just electric.
Yes, sir.
Utilities.
Yes, sir.
And I'll certainly take it back to my water and wastewater clients. But if the commission's going to consider this issue, it may be worth opening it up across utilities sector.
Yes, that's a good idea. Yeah, we won't include this, everybody. We'll include this in a workshop for all of the utilities to participate. If that's okay with everybody, I think that's more efficient. And
I'm not saying that I disagree with what Mr. Anselmo said.
Right.
We just don't have a position yet.
Yes, sir. I think too, if everybody can think, and perhaps we can't, even if we don't, if a definition is not recommended, are there other ways to inform the customer? I don't know that it is an issue beyond what the commission has seen in a complaint case, but is there any other information that we should provide to the account holder? That's really the ultimate goal here. Maybe yes, maybe no.
Keep in mind the account holder changes really frequently, and that's the point, especially behind the K rule. So
yeah,
that might be a difficult endeavor,
yes,
considering how quickly it changes.
Yes, and that's probably the case. But I think we should. Yeah. The more we talk about it, meaning the second workshop, that'll be in it. I won't bother you again. People are aware. That's the main point. I think even if we don't, if nothing, no written policy or regulation is created, we've had the discussion. I think that's important. Okay. All right. So
This is Bill
everybody.
Burns.
Oh, Mr. Burns, yes, sir.
I just want to note that CCMA doesn't have a dog in the fight of what needs to be notified and a lot of the issues that council have been talking about. So, but it struck me as I read that that there are probably a lot of customers in South Carolina whose household is not led by someone who fits his.
Right.
There's probably a lot of women head of households, and,
Right.
and I don't know if you're gonna reword or go into this. It might be worth trying to fix that. But it struck me. I thought nobody had mentioned it, so I thought I would throw that in there as well.
Yes, sir.
Get all woke on us now.
No, it's just factual. So anyway, but I thought I would throw that in there, but because I was surprised it hadn't come up. But that's
Yes,
all. Nothing to add to other comments from council.
Okay. Thank you, Mr. Burns. Okay, everyone. So our second workshop for Article 3, we will talk about 315 again, please. 332, 333, 315 as it relates to how we arrive at the repair costs. 332, estimate methodology for ORS. 333, the interest on deposits. Mr. 339. Those are my follow-up agenda items, and then we'll talk about as a collective with all the utilities, member of household. Okay. Mr. Anselmo, Mr. Burgess, Ms. Hudson, thank you so much for participating. Thank you, Mr. Wellborn and Ms. Henderson. Mr. Hall, we appreciate you participating. Thank you, Mr. Mushton and Ms. Binge. Thank you, Mr. Witt and Mr. Burns, and thank you, Mr. Terraney. I don't think I missed anyone. Okay.
Thank you, Ms. Boyd.
Have a safe weekend. Thank you.
Thank you.